Hey cats and kits, Captain Zorikh here, and yes, I promise I will get my hair cut very soon. But I got something big news here. You remember how, well, first off, we all know that I'm in that big court case involving 182 Graham Avenue, etc. And you remember how back on December 10th, the lock on the door, front door of the building, 182 Graham Avenue, was changed, and I was denied a key. So I, that very same day, filed an illegal lockout claim on the basis that, as a rent-controlled tenant of the building, of a room on the third floor, I still had access to the kitchen, the bathroom, and the mailbox, regardless of the fact that my room, my individual room, 2D, was under an order to repair slash vacate order, which meant that no one was allowed to live in it. Well, so I filed that. A few days later, we went to the hearing was held. We had virtual court, and where I found out that there was an order to a motion to dismiss filed by the respondent in the person of Ron Hariri, the attorney for the respondent, who was Antonio Hernan Cook of Urban Properties, the building manager of 182 Graham Avenue, and the guy who actually ordered the changing of the lock, and that I would not get a key. And so the judge invited me to write a response to this motion to dismiss. And I'm skipping a whole lot of details. You can scroll back on Facebook, or if you're watching this on YouTube, scroll back on YouTube to see the reports of what happened on those previous days, or I should have this all written up on 182saga.info, info, any day now. Anywho, and then I wanted to bring an architect over to look at the space so that I could make an educated comment about their plans for the building, and they denied to give the architects access. Fortunately, I know someone who lives there, so that person was able to give me access to the building, but not to any of the parts of the building that we can't access, like the apartment on the second floor, the rooms on the fourth floor, my room, the cellar, the first floor store, that sort of thing, the subcellar. But we had two hearing dates, and after those two hearing dates, the judge said that he would let us know where his decision on the motion to dismiss, and then he would let us know whether or not there would be another hearing or whatever. He left it very open in the air. When he would let us know and what he would let us know. So here it is. This is the motion. This is the decision / order by the Honorable Judge Stoller, Judge of Housing Court. Recitation as required by CPLR number 2219A of the papers considered in review of this motion. Zorikh Lequidre petitioner against Antonio Hernan Cook and Urban Properties LLC, respondents, index number 59905/2020. Okay, this is going to get into, this is 10 pages of legalese here, but it shows two things. One, how thorough Ron Hariri was in his motion to dismiss. Two, how complete Judge Stoller was in his response. So, grab your popcorn and have a listen. I'll annotate where necessary. Okay, pages, notice of motion and supplemental affirmation annex numbered 1 and 2, affirmation and opposition 3. I'm going to spare you the reading of the motion because basically this decision reviews it all. Okay. Upon the foregoing papers, the decision and order on this motion are as follows. Zorikh Lequidre, that's me, the petitioner of this proceeding, petitioner, commenced this proceeding against Antonio Hernan Cook and Urban Properties LLC, respondents, seeking possession of 182 Graham Avenue, Apartment 2D, Brooklyn, New York, the subject premises. And yes, that is what I filled out because it was a boilerplate court form and there wasn't, I thought that was just putting my address in there. But anyway, pursuant to RPAPL number 317, parentheses 10, on the allegation that the respondents locked petitioner out of the subject premises. Respondents now move on a pre-answer basis to dismiss on the grounds of a defense based on documentary evidence, lack of subject matter jurisdiction, prior action pending, and lack of personal jurisdiction for summary judgment in their favor and for sanctions against petitioner. So, let's see what the judge has to say about that. Okay, background. Both the Department of Housing Preservation and Development of both the Department of Housing Preservation and Development of the City of New York, HPD, and the New York City Department Buildings, DOB, placed vacate orders, on the subject premises, deeming it to be unsafe for residential occupancy because it lacks a second means of egress. Footnote, HPD has the power to order any dwelling which is unfit for human habitation to be vacated. NYC Admin Code number 27-2139, New York City Charter number 1802, as does DOB, NYC Admin Code number 26-127B. In other words, if there was a fire in the hallway, I wouldn't be able to get out of the building if I was in my room, so therefore I can't live in that room. After HPD and DOP placed the vacate orders, petitioner commenced a prior lockout proceeding against the respondent captioned at Lequidre v. Portrich Realty and Urban Properties, index number L/T 87911/2019, Civil Court King's Company, quote, the prior proceeding. That was back when we're filing the original HP case. We also filed an illegal lockout case because we just wanted to cover every angle of attack and defense with regards to what building management was doing against us. The court dismissed the prior proceeding by an order dated September 2nd, 2020, the prior order. The prior order found, inter alia, that the New York State Division of Housing and Community Renewal, DHCR, had made a determination in 2018 before the placement of the vacate orders that the petitioner is a tenant of subject premises pursuant to the rent stabilization law. The prior order dismissed the prior proceeding because the vacate orders affected the petitioner's removal from the subject premises, not any of the respondent's actions. The record on this motion practice shows that the petitioner also commenced a proceeding against the respondents pursuant to New York City Civil Court Act number 110, the HP proceeding that I mentioned earlier. Number 2, the record on this motion practice does not include a caption or index number of this proceeding. Seeking an order correcting the condition leading to the vacate orders. The HP proceeding is pending as of the return date of this motion. In fact, the next hearing date is January 15th, on which Judge Weisberg wants both myself and the respondents to present motions as to why the case should or should not be dismissed. We won't go into those details now, except to say that's the status of that case. Jurisdictional grounds for dismissal is the heading of the next section of this order here. Respondents move to dismiss on the basis that the court lacks subject matter jurisdiction. Respondents argue that the vacate orders preclude the petitioner's occupancy of the subject premises and thus deprive him of the remedy he seeks herein. Subject matter jurisdiction, however, concerns the competence of a court to entertain a particular kind of litigation. Gager v. White, 53 NY 2nd, 475, 485, N.2, 1981. Not an inability to reach the merits of a cause of action. Lax versus Lax, 41 New York 2nd, or is that 2D, 71, 75, 1976, lack of jurisdiction should not be used to mean merely that elements of a cause of action are absent, but that the matter before the court was not the kind of matter on which the court had power to rule. That's from I forget if that's, I can't tell if that's before or after, but Manhattan Telecoms Corporation versus H&A Locksmith Inc., 21 NY 3D 200 203 2013. Also Garcia v. Government EMPS Insurance Company 130 AD 3D 870871 2nd Department 2015. As this proceeding is a summary proceeding pursuant to RPAPL Article 7, this court is the kind of matter upon which the court may rule. New York City Civil Court Act Number 110, A5. Respondents also move to dismiss on the ground that the court lacks personal jurisdiction over them. However, respondents do not support their motion with a sworn statement from an affidavit with personal knowledge of any defect in service, only an affirmation of an attorney. As an attorney cannot be a fact witness, Thelen LLP versus Omni Control Company, Inc., 79 AD 3D 605606, 1st Department 2010. Leave to appeal denied, 17 NY 3D 718 2011. The court denies the motion to dismiss on jurisdictional grounds without prejudice to the assertion of such defenses at a different posture of this proceeding. Victory number 1. For yours truly, that is. Dismissal on the grounds related to other proceedings. Respondent stated ground for dismissal based upon the prior order, which found that the vacate orders and not any action of the respondents prevented petitioner from occupying the subject premises. Insofar as the vacate order remains in effect, which the record on this motion practice does not gainsay, and insofar as the petition seeks restoration to possession of the subject premises, see, what they're saying is because of the vacate order, I got no access to where I say I ought to have access, meaning the whole building. Anyway, and insofar as the petition seeks restoration to possession of the subject premises, the prior order precludes petitioner from obtaining relief on such an identical claim as the petitioner raises in this proceeding. In other words, they cite Josie versus Gourd, 9 NY 3D 389-90 2007, and U.S. Bank N.A. v. Greenpoint MTGE Funding Inc. 105 AD 3D 639-640 1st Department 2013. In other words, because the previous lockout case said that I don't have a case, I'm not entitled to a key to room 2D, that I'm not entitled to what I'm claiming to be entitled to by this lockout case. That's what the respondent, Ron Hariri, is saying. In opposition to the respondent's motion, petitioner avers that it is not the subject premises that he seeks possession of. Room 2D is what was the subject premises of the previous case, but the common areas of the building in which the subject premises is located. The common area, in particular the kitchen, the bathroom, and the mailbox. Footnote, the subject premises appears to be a single-room occupancy SRO dwelling, hence the location of the kitchen and bathroom outside of the subject premises itself. Are you with me here? The petition only refers to the subject premises, not the common area. However, the judge is realizing that the way I filled out the petition, it only refers to the subject premises, room 2D, not the common area. However, on a motion to dismiss pursuant to CPLR number 3211, the court may consider affidavits a party may submit to remedy any defects in the pleading. In other words, what I said in court and anything I wrote that I submitted after I submitted my petition could be considered if what I actually petitioned for was incorrect, was not what I meant. Okay, however, on a motion to dismiss, and he cites David versus South Nassau Communities Hospital, 26 NY3D 563-572, 2015, and Sargis v. Magarelli, 12 NY 3D 527-531-209, and Leon V. Martinez, 84 NY 2D 8388 1994. This judge did some work. Rock on, Judge Stoller. Okay, moving right along. And even though a petition's misstatement of the premises in a petition is a defect, U.S. Airways Inc. versus Everything Yogurt Brands, love that. 18 MIS Miscellaneous 3D 136A, Appellate Term 2nd Department 2008. It is an amendable defect. Najjar versus Cooper, 35 Miscellaneous 3D, I hope that means miscellaneous, 129A, Appellate Term 2nd Department 2012, and 191 Christie LLC versus Saunier, 21 Miscellaneous 3D, 144A, Appellate Term 1st Department 2008, and Briskin versus Williams, 43 Mis 3D, 2019, A, Civil Court, NY County, 2014. In other words, I filled out the form wrong, I corrected it in court and in papers, and that's cool. All right, as noted above, respondents move for summary judgment. Oh, so that makes victory number 2. As noted above, respondents move for summary judgment in the event that the court denied the motion to dismiss. 4. Respondents annexed an answer to their motion in the event that the court denied their pre-answer motion to dismiss. I was not aware of this. In other words, if you deny the motion to dismiss, make a judgment now, Your Honor, we beg you. If the court considers petitioner's opposition to respondent's motion on standards applicable to summary judgment motions, those standards closely resemble the standards applied to a motion to dismiss, to wit, a litigant may bolster defects in a pleading in submissions in opposition to a summary judgment motion. He cites Nassau Trust County versus Montrose Concrete Products Corp., 56 NY2D 175182, 1982. Alvord and Swift v. Stewart M. Mueller Construction Company, 46 NY2D 276 279, 1978. Bergdorfer versus CLK/HP90 Merrick LLC, 170 AD 3D 427 428, 1st Department 2019, and Perry versus Edwards, 79 AD 3D 1629 1630-31, 4th Department 2010, and Ramos versus Jake Realty Company, 21 AD 3D 744 745, 1st Department 2005, and Ebk Amro Asset Management versus Kaiser 256 AD 2D 161 162, 1st Department 1998, and Machia versus Liggett 67 AD 2D 905, 2nd Department 1979. Whew! This judge did some work. Either that or he knows this stuff off the top of his head, in which case, whew! These people went to law school for a reason, okay? Where are we? Accordingly, the judge considers respondent's motion in the context presented by petitioner's opposition that he really seeks access to the common area, not possession of the subject premises. Whew, victory number 3. Okay, the record on this motion practice shows that petitioner is a rent-stabilized tenant of the subject premises. Footnote: the court notes that respondents indicated at oral argument of the motion that they contested DHCR's finding that petitioner is a rent-stabilized tenant of the subject premises and that they were challenging GHCR's order as such by a proceeding brought according to Article 78 of the CPLR. However, a determination of a tribunal binds the court even during the pendency of an appeal of that determination. De Silva versus Musso, 76 NY 2D 436440, 1990. Matter of State NY versus Richard TT, 127 AD 3D 1528 1528-29, 3rd Department 2015. And furthermore, the period of time in which to file an Article 78 has expired, so I don't think that 78 is going to file, although they have filed a motion to give an exception, and we've sent an answer to that, so that's all back in the works. All right. Anywho, so, where were we? Yeah. The record on this motion practice shows that petitioner is a rent-stabilized tenant of the subject premises, a status that the vacate orders do not change. And he cites Ident versus Vickers Management, 150 AD 2D 202-204, First Department, 1989, citing matter of Department of Buildings, Philco Realty Corp, 14 NY 2D 291 302, N.2, number 2, 1964, and Garber versus Egger, 132 NYS 2D 371, appellate term, First Department, 1954. Wow, 1954. Unless the condition causing the vacate order cannot be cured. Quills versus Term Equities, 22 AD 3D 417. 421, First Department, 2005. 17994 ST LLC v. Hassan, 2018, NY Slip Op 33161U, paragraph 5, South Court, NY County. Whether the court evaluates respondent's motion on the standards of a CPLR number 3211A1 motion, i.e., if the submissions resolve all of the factual issues as matter of law, Colchins versus Evolution Markets, Inc., 31 NY 3D 100 106 2018, or standards of a summary judgment motion, i.e., tendering evidence sufficient to eliminate any material issues of fact, Wonderly versus City of Poughkeepsie, 185 AD 3D 632 633, Second Department, 2020, Kebe versus City of New York, 113 AD 3D 512 513, First Department, 2014. The record on this motion practice does not prove that respondents cannot cure the condition precipitating the vacate orders. In other words, I'm a rent-stabilized tenant. The vacate order does not make me not a rent-stabilized tenant unless they can't fix the condition that led to the vacate order, and there's nothing on the record that says that they can't. So, indeed, given that an apartment can only be rent-stabilized if it is at least capable of being legalized, Walensky versus Key Yip Realty Corp. 2 NY 3D 487 493 2004, and Acevedo versus Piano Building LLC 70 AD 3D 124 130, First Department, 2009, and 142 Fulton LLC versus Hegarty 41 AD 3D 286 288, First Department, 2007, and Dwayne Thomas LLC versus Whalen 35 AD 3D 232 233, First Department, 2006. Leave to appeal denied, 2007, New York Appellate Division, Lexus 1956, First Department, 2007. DHCR's finding that petitioner is a rent-stabilized tenant of the subject premises offers at the very least indicia that respondents may possibly be able to legalize subject premises. In fact, they've been saying, we want to legalize the subject premises all along. And you know what? We, the petitioners, are not 100% against that. We just want to make sure it's done with a priority set for the vacated tenants to be returned to where they've been vacated from. Anyway, insofar as so that's victory number, what are we up to, 4 now? Insofar as the record on this motion practice, in particular the finding of the prior order, shows that the petitioner is a rent-stabilized tenant of the subject premises, then, which that previous paragraph just settled, the petitioner has standing to commence an illegal lockout proceeding even if he is not physically present in the subject premises because of vacate orders. Fischel versus Baronelli Limited, 119 MISC 2D 625626, Civil Court NYCO County, 1983, Sachs J. And Darob Holding Company versus House of Pile Fabrics, loving these names, Inc., 62 Miscellaneous 2D 899 900, Civil Court New York County, 1970. Petitioner's allegation in his opposition that respondents changed the locks leading to the common area therefore satisfies the element of petitioner's cause of action that respondents use forcible means of excluding him. Compare West Broadway Glass Company versus Namaskar of Soho, Inc., 11 Miscellaneous 3D 144A, Appellate Term, First Department, 2006, in parentheses, an elaborate, cumbersome, and unpredictable procedure for access, constitutes an illegal lockout. Now, I don't know if by that he was referring to when the respondents kept on saying, hey, the petitioner can call and we can set up a supervised time where he can visit, or he can make arrangements with the people he knows in the building, is what the judge is considering elaborate, cumbersome, and unpredictable procedure. But I'll take victory number 5 right there. Thank you very much. With regard to respondent's argument that the prior order precludes petitioner's current cause of action, as described in his opposition to the motion, petitioner's cause of action here seeks restoration to access of the common area, not possession of the subject premises, room 2D. Accordingly, the issues are not identical, a requirement for collateral estoppel. In other words, this condition is not identical to the condition of the previous illegal lockout order. Therefore, you can't use the illegal lockout order to judge on this lockout order. And he cites City of New York versus Weisbach Electrical Company, 9 NY 3D 124 128 2007. Only one citing, thank God. As the parties did not previously litigate the issue of petitioner's access to the common area, the prior order does not collaterally estop the petitioner's cause of action herein. Again, only one citing, BTC Holdings LLC versus Village of Chester, 2020 NY, slip op 07157, Appellate Division, 2nd Department, 2020. Victory number 6. Respondents argue that the New York State's transactional approach to res judicia bars petitioner's cause of action here, i.e., petitioner cannot now litigate an issue that he could have previously raised. Call. All right. Okay, I'll get back to that. Where were we? Respondents argue that New York State's transactional approach to res judicia bars petitioner's cause of action here, i.e., petitioner cannot now litigate an issue that he could have previously raised, even if he did not previously raise it. Josie Spura 9 NY3D at 389-90, U.S. Bank, N.A. Supra 105 AD 3D at 640. Again, only one citing, thank you. Petitioner, however, points out in opposition that respondents had not changed the locks to the common area until December 10th, 2020, 3 months after the prior order. Res judicia does not apply when an issue arises subsequent to the prior adjudication. Oh boy, deep breath here. Citing Kinberg versus Kinberg 59 AD 3D 236 238, 1st Department 2009, Rapid Electrical Company Inc. versus Royal Holding Corp. 47 AD 2D 615616, 1st Department 1975. Olawayan versus 520 West 43rd Street Partners LLC, 34 MISC 3D 130A, Appellate Term, 1st Department 2011. Robert B. Jetter MD PLLC versus 737 Park Avenue Acquisition LLC, 2017 New York Slip Op 30797 U SCT NYCO. That is when the cause of action did not accrue until after the previous litigation. O'Brien versus Syracuse, 54 New York 353358 1981, and Breslin Realty Development Court versus Shaw, 72 AD 3D 2582666, 2nd Department 2010. Victory number 7. This is your and my tax dollars at work, folks. Okay, and I think we're getting our money's worth here. Respondents also move to dismiss pursuant to CPLR 3211A4, i.e., that a pending prior action is the appropriate forum to resolve petitioner's cause of action. In other words, I can take this to the HP case. I don't need to file another illegal lockout to handle this. While the record of the judge continues. While the record evinces no dispute that petitioner has commenced the HP proceeding against respondents, which is pending as of this writing, The central relief sought in HP proceeding is in order to correct a violation. NYC Admin Code 27-211-5H1, not an adjudication of possession. Without such an identity of cause of action, CPLR number 3211A4 does not require dismissal. Kent, and he cites Kent Development Company versus Lichione, 37 NY 2D, 899-901, 1975. Grave v. Grave, 219 AD 2D 535, First Department, 1995. Chrysler Capital Corp versus Citibank, NA, 186 AD 2D 395. 394, First Department, 1992. And Morgulus versus J. Udell Realty, Inc., 161 AD 2D 211, First Department, 1990. And finally, Parker versus Rich, 140 AD 2D 177, 178 to 179, First Department, 1988. Victory number 8, cats and kits. Okay, and I do this because this is German for 3, and it's just easier than this for me to do with my hands, okay? That doesn't mean white power. That was an after-the-fact bullshit thing. Okay, dismissal based on futility. All right. As I might have mentioned, the motion to dismiss had 3 parts. It was to dismiss because this was about a cause that was already adjudicated, trying to get into Room 2D. Also, they wanted the judge to rule against me being the futility of the case. They called it frivolous. And third, that it was libelous because I said that there had been no previous adjudication towards this issue. Here's where we get to frivolous, which the judge calls futility. Dismissal based on futility. Even if petitioner has a cause of action sounding in an illegal lockout, restoration to possession may not be an appropriate remedy, while restoration would be futile, such as where restoration would only forestall the inevitable eviction. And the respondent, Hariri, cited Sukuna versus 365 Canal Corp, 48 AD 3D 359, First Department, 2008. Pied-à-Terre Networks Corporation versus Porto Resources, LLC, 33 Miscellaneous 3D 126A, Appellate Term, First Department, 2011. And Friends of Yelverton, Inc. versus 163rd Street Improvement Council, Inc., 135 Miscellaneous 2D, 275, and 281 to 282, Civil Court, Bronx County, 1986. Respondents argue that this proposition applies here. By the way, thank you all of you who are sticking through all this. It gives me reason for living. Respondents cite Cordova versus 1217 Bedford Realty LLC, 67 MISC 3 1206A, Civ Court, Kings County, 2020, in support of their argument. However, Cordova Supra concerned a short-term occupant who rented space from someone whose authority to rent the space was dubious at best, such that the occupant had no discernible right to possession. By contrast, petitioner in this matter is a 27-year rent-stabilized tenant of the subject premises, accordingly affording petitioner the relief he seeks, which is limited to a key to the common area so he can access, he says the bedroom, but I'm pretty sure he means the bathroom, the kitchen, and his mailbox, would not be an act of futility. To the extent that respondents' argument really concerns a possible inability to legalize residential occupancy so as to effectuate lifting of the vacate orders, the factual record on this motion practice does not develop such a record. Victory number 9. Sanctions. All right. Here is where Hariri attempted to bring down the wrath of legal God on yours truly for having the temerity to say that this illegal lockout case had not been adjudicated before. Let's hear what the judge has to say about that. Sanctions. Respondents move for sanctions against petitioner, in particular because petitioner averred on the petition that he had not made a prior application for the relief sought, a sworn statement that respondents argue is perjury, given the prior proceeding. While respondents have a point as a prima facie matter, as in how it looks on the surface, I'm pretty sure that's what prima facie means, petitioner states in opposition that he understood that he had not sought the same relief on this case as in the prior proceeding, because in this case, he only seeks a key to the common area as opposed to the subject premises. Duh, which was the subject of the prior proceeding. Duh. I don't mean that to you, Your Honor. I mean that to the respondents. Whether conduct is frivolous depends on the unique circumstance of each case. Oh, and by the way, yeah, that counts as victory number 10. Whether conduct is frivolous depends on the unique circumstances of each case. He cites Trian Realty LLC versus Aorindi, 17 MSC, 17 Miscellaneous 3D 1124A, Civil Court Kings County 2007, in determining whether the conduct undertaken was frivolous. The court let's begin that sentence over again. In determining whether the conduct undertaken was frivolous, the court shall consider, inter alia, the circumstances under which the conduct took place, including the time available for investigating the legal or factual basis of the conduct, and whether or not the conduct was continued when its lack of legal or factual basis was apparent, or should have been apparent, or was brought to the attention of the counsel or the party. That is according to a rule here, 22 NYCRR number 130-1.1C3. Hooky ducks. This case is a lockout proceeding, the judge continues, by which its nature is commenced on an exigent basis. In this matter, petitioner commenced the filing of the petition by filing on December 10th, 2020, the day that petitioner alleges that respondents changed the locks to the common areas. Petitioner is a pro se party who signed a boilerplate form provided by the court. These factors do not militate in favor of sanctions. A purpose of sanctions is to advance the public interest. Tag 380. LLC versus Estate of Howard P. Ronson, 69 AD 3D 471 475 First Department 2010, in part to prevent malicious litigation tactics. Levy versus Carroll Management Corp. 260 AD 2D 2734 First Department 1999, and Kernison versus Taylor 171 AD 2D 869, 870, Second Department, 1991. On this record, petitioner did not engage in malicious litigation tactics and sanctioning petitioner for writing the wrong address on a lockout petition would not advance any discernible personal interest. Victory number 11 for yours truly. Okay, now, conclusion, the big kahuna. This is it. This is all the marbles here. I see I'm 11 for 11 on victories here. Let's see how the judge concludes. Thank you all of you who joined. You just came to the good part. No more citing of previous cases here. Let's just read. Conclusion. Accordingly, the court denies respondent's motion to dismiss and motion for summary judgment, deems the proposed answer annexed to their motion to be served and filed, and denies respondent's motion for sanctions. Oh yeah, there was this big 30, 40 part answer in which they made all these claims and stuff, and I responded to that with my own answer, but he just says it's filed and served and doesn't make any comment on it. And denies the respondent's motion for sanctions. The court's denial of this motion is without prejudice to respondents' assertion of the defenses in their answer. The court will restore this matter for a conference to ascertain the court of this litigation over video conference after consulting with the parties over email regarding their availability. This constitutes the decision and order of this court, dated New York, January 4th, 2021. Honorable Jack Stoller, J.H.C. Well, that's game, set, and match for the motion to dismiss. my illegal lockout case regarding the key to the front door to 182 Graham Avenue. So that opens the door for us actually to litigate the case. Now, I don't know how much more there is to say about this case in court that we didn't say in those two hearing dates, except to say it in a more organized manner, maybe. In that last hearing, their big defense weighed on two things. One, this order to dismiss, which was predicated on the fact that I wrote 2D in the place where I should have just wrote the building. And as we saw, that was no big deal. I was able to amend it. Moving on. Their other big defense for not giving me a key to the front door of the building so I can access the kitchen, the bathroom, and my mailbox is that they are afraid that with all these, building violations that they already have on file and the thousands and thousands of dollars of fines they're going to have to pay, they can't take a risk that yours truly is going to violate the order to repair/vacate order on room 2D. And also, they weren't even sure that it was legal for me to access that space when the kitchen, the bathroom, and the mailbox because of the vacate order. Well, that there court order, that there decision says that the kitchen, the bathroom, and the mailbox are not the premises that are covered by the vacate order. Boom, done. Thank you, ma'am. As far as, am I going to violate the vacate order and force my way through one or another locked doors to get into that room? Am I that stupid? Am I really that stupid? And let's look, on the other hand, at who has violated the vacate orders chronologically. Violated or in some other way disrespected, or there's got to be a legal term for what this counts as. The order was incompletely delivered to the tenants by the building manager. He sent us a photograph of what looks like a CRT computer screen showing a portion of the screen that showed the portion of the order. What were we supposed to do with that? That was on the Friday. Then on the Monday, when I got home and started packing, because I'd gotten a phone call and I figured I better pack just in case, Antonio Cook shows up, the building manager that is, with the HPD inspector, and starts telling everybody has to go. It's everybody's being evicted, and this whole building's got to be gutted. And I'm like, no, it's not. And that video's on YouTube, by the way, Antonio on the Rampage, part 1. I'm like, no, it's not only certain rooms. No, all rooms, A, B, C, D, E, and upstairs too. And everybody's got to leave, including you, my friend. That little wink is on that video, Antonio on the Rampage, part 1, on Captain Zorikh's YouTube channel, youtube.com/Captain Zorikh, Zorikh. You can look it up. Or just search Antonio on the Rampage in YouTube, and you'll find it. So there he is, misrepresenting the vacate order. Then he's harassing me as I'm trying to pack and leave. Let's see, by just getting in my face while I'm trying to pack. And then he's harassing me by calling. Fire department showed up, said there was a fire, an anonymous tip that there was a fire hazard there. 3 guesses. They're not allowed to tell us who, but who else was in that building? Who has a reason to call the fire department to say there's a fire case? That was a big hassle. Sending me photographs of my boxes in the hallway when I've already moved those boxes out of the hallway and I'm moving them into a storage space. That's harassment. He's just trying to get in my ass. He's just trying to hassle me. Trying to tell me that I'm no longer living there, that I'm no longer a tenant. These are misrepresentations. Trying to say that I only have 1 day after the vacate order was enforced to get my stuff out. then trying to tell me I have only 7 days when truth is I have 30. When I showed up on day 7, I said I had 30 days. He said, you got 30 minutes. I had to call the police, and I had to call the chief deputy inspector of HPD in order to tell the police to tell Antonio Cook that I had 30 days. Then on top of that, with regards to disrespecting the vacate order, he also denied the validity of a court order that said that he couldn't remove the original lockout case said that he couldn't remove my stuff at all or rent it out to anybody else. So there he goes, violating these court orders, violating misrepresenting vacate orders, and then the big kahuna of violate. Well, and then we had sort of an agreement, me, other petitioners, that Antonio Cook, building management, would not enter our rooms, would not enter the common area without advance notice, making an appointment and all that. And yet I've got videos of like 3 or 4 times in which either Antonio Cook or his associates have entered or granted access to people to my room. And here's the biggest kahuna. Oh yeah, and also I'm still holding off on the biggest kahuna because the notices on the fronts of some of the doors were removed. Mine, the notices on the front of my door fell off by its own. Hey, Scotch tape only lasts so long, right? And when someone went into my room, you can see in the video, he's kicking the notices into the room while an inspector's coming in behind him as if there's nothing to see here. That's in I forget which video that is, but it's on Captain Zorikh YouTube amongst all the other videos. Then he offered to rent me one of the rooms on the 4th floor that was under a vacate order without telling me that the vacate order had been lifted, after it had been renovated, without getting any sort of permits to do renovations. He never had the room inspected. And then he was going to rent that room to me for the same rent that I was paying for my original room. And when I asked him if this was going to be just a temporary arrangement until my original room would be fixed, he said, that's going to be a long time coming, buddy. And he basically held it hostage until another tenant who had 2 rooms would give up one of their 2 rooms. I'm making this... Yes, it is complicated, folks. And I still haven't gotten to the big kahuna. When I wouldn't take the room and another one of our vacated petitioners wouldn't take another room, he then rented those 2 rooms to associates of his, people he knows, or maybe friend of a friend, whatever. Well, we call 311 on that right away. And on the day that those tenants had to leave the building, they were moving out of the building, Antonio Hernan Cook, Jamie Feliciano, his now erstwhile superintendent, and the unknown man who has been involved in other egregious acts by Antonio Cook. There are police reports and hospital reports about these egregious acts. Entered my room, and while Jamie was picking up the notices and looking around for tape or stapler or glue that he could stick them up on the wall, Antonio Hernan Cook picked up an electronic keyboard and smashed it against a shelf. He attempted to pull down my loft bed, but that was too well made and secured to the wall. He attempted to pull down a shelf unit, but that was too well made and secured to the wall. However, he flung the keyboard across the room. He flung boxes across the room with his hand protected by a plastic sheet. I don't know if he was trying to hide fingertip prints or what. He flung the swivel chair as far as it would go across the wall. He found an old can with some craft materials in there, pull tabs from old soda cans that I was going to make a chainmail shirt out of, and emptied that can onto the floor, and then thought for half a second about putting the can back on the shelf, flung it across the room instead. And then he noticed that I had a full-length mirror there against the wall. And he picked up, those old hand crank pencil sharpeners that you got in high school? Well, I had one of these that I'd taken home from an architectural office that I'd worked in when it was being discarded, and it was still there. I left it behind, and he picked that up, flung it against that full-length mirror, and it shattered all over the place. It shattered so much that when he tried to open the door to leave, the door got stuck on the mirror shards. That video is on YouTube. Antonio Cook Trashes My Room. Look up the one that's called Special Edition, because that's got it's got the Facebook Live that I made in the car heading from work, that I had to leave in the middle of work, when I saw the video on my security camera of them doing this. And I'd called the cops, and the cops showed up, and he wasn't there anymore, and so they took the police report, and then you got the video, and it's annotated. It describes what each of the things in the video are, like the 27 8x10 glossy photographs. And then there's the after-action report or post-mortem. That's in Antonio Cook Trashes My Room Special Edition. Search for it on YouTube. It's on youtube.com/Captain Zorikh. Wow. Okay, that's all I got for tonight. Hey, Phil. Yeah, we're calling everybody. We're calling everybody. Okay, so let me say quick hellos to everybody who stuck it out and to any portion of this. Phil Fiumano of New York Rocks on Staten Island Cable. You still doing New York Rocks, Phil? I love that show. Drita, Mitchell, Herbert, Carissa, Joaquin, Jim, Digger, Ted, Mike, Heather, Greg, Alberto, Paola, Jasmine, Mark, and another Mark. I get two Marks, one with a C and one with a K. I don't know sign language. That just kind of looks like a K, and that looks kind of like a C. So thank you all for watching. I sent an email back to the court attorney who had sent me this, saying, hey, I'm available every morning before 1 p.m. because I work from 2 to 6 with a day job, and I got a night job. Both essential jobs, by the way. And begging them to have it sooner rather than later, because like I said, or did I mention this, they originally wanted to, Ron Hariri, the defense for the respondent, Antonio Hernan Cook, the building manager, 182 Graham Avenue, wanted to adjourn this illegal lockout case to coincide with the January 15th return date for the, HP case. However, two things. One, we're not in the same building anymore. We're all virtual. We're all online. We're all doing it by computer. And number two, as I said to him, nice, Ron, you want to adjourn this to the day of the HP case so that if you win the HP case, you will be relieved of not having to do what a court may order to you to do in this case, because by then that case might have been dismissed and this case moot. Nuh-uh, no way, we ain't playing that, Holmes. So that's why I wrote up my response to their order to dismiss in less than a week. 5 days, actually. That's why I said what I had to say in the hearing. And that's why, and I can only guess what, outside of 10 pages of legalese and citing precedents, was in Judge Stoller's mind. But Judge Stoller was awesome enough to let me say my piece, and he was awesome enough to give me 11 out of 11, a clean sweep on this, and on every claim in the motion to dismiss and in the conclusion. Motion dismissed. Let's go to court, Ron. No pussyfooting around. No more delaying tactics. Give me my frickin' key and be a man about this, huh? I was about to say be a man, not a lawyer, but there are some lawyers who are men. Gerald Capel's a man. He's not just a man, he's a mensch. He's been my lawyer, and he's been writing the smackdowns, and he's been finding the cases. I only just wish that the judge would rule in my case. Hey, Cartier. Caught up with some of the videos on YouTube. Horrible landlord, by the way. Awesome setup with the bed. Very creative. Thank you, Cartier. And James Palumbo. I'll get to you in just a sec. Let me just answer this guy because I want to close with you. You still do New York Rocks TV. Built my own studio, not at the studio in Staten Island. Too much politics at public access TV. You need a lawyer to produce there. Okay, I'm going to look you up. NY Rocks TV. Still got the t-shirt you gave me. Phil Fiumanu gave me a few guest spots on his show. Hey, maybe I can come on your show again, Phil? The Death Star Repairman is still at work. Okay, and now, James. Heard about your son. He meant a lot to me, and he meant a lot to a lot of us. That was a moment of silence because I have nothing else to say beyond that. Okay, thank you very much, everybody. Captain Zorikh's coming at you. I love you all. Clean up, cover up. Call your loved ones, because you never know what's going to happen tomorrow. I'm going to write a letter to my uncle in France right now.